This bill proposes to let the government secretly cut a Canadian's phone or internet service. Cabinet minister would have the power to issue the order, would prohibit that the existence of the order to cut that service prohibit its revelation, and that the order even existed.
Buried within the so-called Strong Borders Act are sweeping new powers to government agencies to demand internet subscriber data. For example, Section 487.0121 of the Criminal Code, the proposed section, would allow police and CSIS officers to demand customer information from any company providing public services, including banks, telecoms, and social media, on a mere suspicion without judicial authorization. Have I got that right?
Right.
With no requirement for privacy impact assessments before these laws or regulations are passed, and with the serious implications that they have on Canadians' privacy, isn't Parliament simply being asked to grant sweeping powers of surveillance to the government without a formal review by the commissioner that Canadians, that Parliament has asked to do that very thing?
This guy's garage. Like and subscribe.
I would like to start by welcoming Monsieur Philippe Dufresne, who is the Privacy Commissioner of Canada. Mr. Dufresne, I know you've been extremely busy lately, and I want to thank you for being with the committee this morning.
Well, good morning, Commissioner. I have questions for you about legislation Bill C-8. There have been a pretty broad chorus of voices that are concerned about the sweeping and secret powers that cabinet ministers would have over the internet access and telephone access for individual Canadians, the power to secret powers to seize private data without warrant and conceal those actions from the public. So would secret orders to disable an individual's telecommunications access be inconsistent with the principles of the Privacy Act, and if so, why, sir?
Thank you for the question. So in the last Parliament, I appeared on Bill C-26 and talked about some of these issues when legislation aims at giving more power to the state to protect infrastructure and to disable and to take certain steps. And as Commissioner, I've always stated that privacy is not an obstacle to public interest. It's not an obstacle to national security or to strong economy. But we need to make sure that by protecting national security, we're not doing so at the expense of privacy. And so in cases like this, what I said to the committee was that we needed to put in the legislation a criterion on necessity and proportionality, making sure that the exercise of those powers is going to be tested from a privacy perspective to say, is this necessary? Does it achieve the result for which it's been put in place? And is it proportional? So that's the substantive element. And you mentioned secrecy. In certain instances, secrecy is necessary, but it should be challenged, and there should be ways for some reports to be made to appropriate authorities. It doesn't have to be necessarily to make it public, but reports to my office, reports to a national committee of parliamentarians, or other means.
And so in your review of this proposed legislation, does it check all of those boxes?
Well, I will be waiting to testify on C-8 when called, and we're reviewing that very, very carefully. But there is, I think, more to be done in terms of the reporting mechanism and the necessity and proportionality.
I would say for sure that there's more to be done. This bill proposes to let the government secretly cut a Canadian's phone or internet service, and the cabinet minister would have the power to issue the order, would prohibit that the existence of the order to cut that service prohibit its revelation, and that the order even existed, which would, of course, eliminate the ability for anyone, including you in your role as commissioner, to have any oversight whatsoever. Isn't this a direct circumvention of the act over which your mandate is concerned?
Well, that's why, again, to make sure that we're not making it more difficult to raise rights and to protect privacy, reporting to appropriate authority, even if done in a confidential manner, is something that I recommend. Making sure that there is ability for my office to be aware of it, to be able to raise questions. In some instances, a report to Parliament is appropriate. A report to committee is appropriate. And so this should be part of the discussion and the assessment to say, what type of reporting is there? Is it enough? But certainly, in my view, there should be confidential reporting to some authority who would be able to raise questions about it.
Currently, that doesn't exist in the legislation. What you're describing, what you describe as essential, is not included in the legislation. Bill C-8 lets a minister compel data without judicial oversight. So this also creates a risk of a parallel system where Canadians' personal information, their personal data, can be seized in secret, again, with no redress by individual Canadians or by your office. Isn't this antithetical to the type of system that your office has been designed to protect?
Well, if my office is not aware of something happening, of course, we can't raise questions about it. We can't assist Canadians. And so I think, again, there will be instances where making something known to the public may not be appropriate, but we should challenge a claim to absolute secrecy. We should make sure that there's appropriate reporting to the appropriate authorities and that there is an appropriate means to raise questions.
Right. Of course, if your office doesn't know that the law is being broken, then I guess the government's contention is that they haven't broken the law. Do you think that a vague standard like, quote, any threat, which is the term used in the legislation, undermines safeguards in the Privacy Act, such as the requirement that collection or use must be necessary, proportionate, and authorized by law?
Well, we've advocated in the past, and as I say, I expect to be called specifically on this bill to address it, but as a general proposition, I recommend a necessity and proportionality to be in the legislation, made explicit, so that there's a strong test. Yeah.
The specific tools that law enforcement might require, do you have concerns about timeliness? Do you have concerns about national security and how these interface with the privacy regime? Can you talk a little bit about that?
Well, it's important for privacy authorities and national security authorities to talk to one another, to work together. So we work closely with NSIRA, National Security Intelligence Agency, and one of my goals is that we're not at cross purposes. So I don't want privacy to stand in the way of national security or law enforcement. And that's why we're working very closely with a number of bodies, competition authorities, copyright, but also FinTrack. So in terms of money laundering, financial crimes, we work very closely with them and Department of Finance to create more opportunities for banks to share information, to detect fraudulent and modern slavery types fraud and terrorism financing, but subjecting it to codes of practice that are reviewed by my office. So in that sense, there is protection of privacy. There is a demonstration that the privacy aspect is considered, but at the same time, we're allowing the authorities to have the tools that they need.
You read my mind in terms of where I was headed, which was actually around the uptick that we're seeing in online fraud, online scams, and how personal privacy is actually being misused and abused. And are there ways that we can do a better job of actually trying to crack down on the illicit distribution of personal information that's allowing bad actors to access personal information and use it in these ways?
Well, it is this collaboration between all players. So I work collaboratively with my colleagues, the other privacy commissioners, but also with cybersecurity experts in Canada and around the world. So we need to bring all of this together to say what are the best practices, what are the challenges, how do we do it by building privacy in the design, but building security in the design. So I think cyber breaches is a great example where it's a security issue, it's a privacy issue. So we need to work together to make sure that we have the tools that we need. We're not doing things at the expense of privacy. We're not doing things at the expense of security.
Commissioner, the charter jurisprudence based upon the Supreme Court's 2014 Spencer decision and the more recent 2024 Bykovitz decision is clear. Access to personal data requires prior judicial authorization, correct?
Yes, those were the findings of the court.
Okay, and looking at the Bykovitz decision, the court confirmed that subscriber data is, quote, the key to unlocking a person's identity and online activity, and based upon that, the court affirmed that even IP addresses attract a reasonable expectation of privacy and therefore cannot be obtained without a warrant, correct?
Well, that was a finding in that case. Again, the argument was this information is not specific enough, so we can ask and obtain it. And in the court really found that we can draw so much about individuals with these types of data points, and so in that case found that a warrant was required.
Okay, well, thank you for that. And to satisfy, in order to obtain a warrant or a production order in this type of context, the standard that would have to be met is reasonable belief. Is that correct?
Reasonable belief, there's some instances where under the law it will be reasonable suspicion. So I think that is where some of my recommendations are, to the effect that when we're talking about sensitive information, it should be reasonable belief. We should have a more rigorous standard to assess that.
Okay. So with that in mind, I want to ask you some questions about parts 14 and 15 of the Liberal government's Bill C2, buried within the so-called Strong Borders Act, are sweeping new powers to government agencies to demand Internet subscriber data. For example, Section 487.0121 of the Criminal Code, the proposed section, would allow police and CSIS officers to demand customer information from any company providing public services, including banks, telecoms, and social media, on a mere suspicion without judicial authorization. Have I got that right?
Right.
Okay. So in terms of understanding the implications of what that section would enable law enforcement to do. Law enforcement, for example, could compel a bank without a warrant to reveal whether an individual is a client of a bank, how long they've been a client for, where they have accessed banking services, and provide the name of any person who has provided services to that individual. Is that fair?
I don't have the section in front of me, but that sounds right.
And it would provide warrantless access to subscriber data, including IP addresses.
Again,
right?
Sounds right.
That sounds right. And so it would seem to me that completely eviscerates the standards set out in Spencer and in Bykovitz, right?
Well, it modifies it. Parliament can do that. The question is it necessary and appropriate? And so when we look at this, we ask questions about why is it suspicion and not belief? Is it rigorous enough? Is there enough reporting? These types of questions.
Yeah, but it raises serious privacy implications, does it not?
It has privacy implications. You're making it easier to obtain the data.
And do you have any concerns about that?
Well, again, I'm giving in advance the testimony that I'm going to be given to the committee when called on that specific bill. But certainly, once what we've seen so far is we would have preference in it being reasonable belief as opposed to reasonable suspicion in some of those aspects because of the sensitivity of information. And so there are areas where the standard, in my view, should be higher.
And this would, and the standard would be higher in your view in this context.
Standard of reasonable belief as opposed to reasonable suspicion.
Well, and what about the ability for law enforcement to access sensitive personal information? I think you would concede the information that we're talking about here is sensitive personal information. You'd agree with that?
In many cases, it will be. In some cases, it may not be. But my point is, if we're talking about that sensitive information, the threshold should be higher. There is appropriate places for suspicion, but reasonable belief when we're talking about sensitive information is critical.
Since you've been elected as the chair of the global organization, could you compare Canada to the rest of the world, where we are as a private commissioner or our legislation?
Thank you. So I think Canada is extremely respected around the world, and that was part of my election in that role. And so I think that we are very much a leader in that space, and we punch above our weight, and we want to do that. But I will flag that. Compared to other parts of the world, the fact that my office does not have the power to issue orders and to levy fines, that's an area where we are not as good as the rest of the world. That's a quick fix that we can improve to raise the level of Canadian privacy law to what's around the world. That being said, things like privacy by design, our strong privacy culture, our strong collaboration culture, I think this is something that we can bring to the world, and that's going to be part of my goals in this role.
So we are leaders in the world overall, but why do you think it's important that you would have the authority to lay fines? I just wanted to know your view.
Well, I think it's important because if we want organizations to build privacy in the design, we want privacy to invest money and time in building those things, we need to give the incentive for them to do that. It's hard for a CEO and for a board of directors to say, we're going to spend millions of dollars when there's absolutely no risk and no financial consequence if they don't. It becomes something that feels like a nice to do, not something that you must do. So that's why this authority is important, and it's certainly around the world, those risks, they exist for other jurisdictions. They don't exist here. That being said, I'm going to continue to use the tools that I have, including making reports public, including calling out organizations. But I think those two powers, they would make the system faster, less expensive, more transparent, and more effective.
In June, you announced that you would like to have a youth wing of your group. Why is it that important, and is it going to incur additional expenses to your office?
I didn't hear the end of your question.
We're over time. I'm going to give Mr. Saini one more chance to ask the question, but I need a very quick response, Mr. Dufresne.
In June, you have asked for a creation of the Office of the Privacy Commissioner for Youth, Canada Youth Advisory Board. Why is it important, and is it going to incur additional expenses to your office?
Not significantly, no, and it's important because we need to hear the voice of youth. Children's privacy is one of my priorities. I need their perspective. I need to understand their realities, and that's what this council is going to give me.
Okay. Without meaningful limits, bills like C8, and specifically Bill C8, can hand the government secret, warrantless powers over Canadians' communications. This is a serious setback for privacy. It's also a serious setback for democracy. With no requirement for privacy impact assessments before these laws or regulations are passed, and with the serious implications that they have on Canadians' privacy, isn't Parliament simply being asked to grant sweeping powers of surveillance to the government without a formal review by the body, by the commissioner that Canadians, that Parliament has asked to do that very thing?
Thank you for the question. In fact, privacy impact assessment is something that Treasury Board directive requires government departments to do, but it's not a legal obligation in the Privacy Act. And this is one of the recommendations that I have made to Parliament, and I continue to make. It should be an obligation. There should be the opportunity for my office to give input before the fact when there's a major change, including legislation. So it's something to manage. There's cabinet confidences to be considered, but I would agree that that opportunity would be important.
And so you haven't had that opportunity with Bill C8 and Bill C2?
We're not consulted on the specific pieces of legislation before they're tabled. We have exchanges often after with officials, and they're good exchanges. But I think earlier consultation would make our feedback more meaningful, and our feedback would happen before it's tabled.
I don't think I have a tremendous amount of time left, but to continue to preempt your appearance on Bill C8 at another committee, do you have a particular amendment or guardrail that you'd like to see included in that bill before it comes out of committee? Not specifically at this stage, but I'll just repeat. Necessity and proportionality, strict criteria for the exercise of powers, and appropriate transparency and reporting mechanisms. These are the things that we're looking for.